Good morning, everyone. Thank you so much for joining me this morning. My name is Katie Schaefer. I am a member in our Syracuse office, part of the school law practice and also the labor and employment department. Thanks for joining us for our monthly installment of School Law 101, where we try to bring you interesting trainings, recent topics. And one thing that we keep hearing from clients, and I've seen a lot in my practice, is the need for training on investigations, kind of your day-to-day personnel and student investigations. So without further ado, let's go ahead and jump into it. Next slide, Katie. So the overall roadmap of an investigation, right? And each one is going to vary, but think in general of terms, this is what it's typically going to look like, right? The first part and the most important part is recognizing the need for an investigation. And sounds silly, but sometimes that is overlooked and can be very fatal to the issue. So recognizing the need for an investigation is important. Selecting the appropriate investigator, who's going to do it, develop your plan. What's it going to look like? What are the stages going to look like in general? Actually conduct the investigation, make your determinations based on those findings and review it with that final filter. Maybe that's your decision makers, maybe that's legal counsel. Then document the investigation. What does that look like? Is it a report? Is it a memo to file? Is it something else? And then recommend your appropriate action, right? Because we've done all this, we want to make sure we take the appropriate action. Next slide. So when we talk about recognizing the need for an investigation, there's lots of different scenarios that could prompt us to need an investigation, either for our employees or our students. Sometimes it might be required by law, right? If it's an allegation of discrimination or harassment, if it's an allegation related to students under DASA, the human rights law, Title IX. As many of you probably know, the human rights law was amended in the last few years to bring school districts and students under its purview. So I have seen more claims regarding, racial harassment, sexual harassment that are brought as human rights law claims under the Division of Human Rights, for example. So all those things are, things that would be required by law. We would want to make sure we have an investigation there. Other reasons why you might conduct an investigation is a violation of your own policy, right? You have a policy put in place by your board that says how conduct's going to happen. If it's alleged a violation of that, you would want an investigation to show whether or not that was true. Investigations can be really helpful to avoid negligent supervision, negligent retention claims, and those are really premised on the fact that, gee, employer, you should have known that this was a risk, and had you looked into it, you would have realized you couldn't keep this person in this position, and it would have avoided this harm. So by doing an investigation, that can really help prevent those types of claims. Just cause is another reason for anyone with collective bargaining agreements, which a lot of you probably have. A lot of those contain a just cause provision in there, meaning that before you can discipline an employee, you have to be able to show just cause. An investigation is really necessary to be able to establish those elements. And even when you don't have a just cause provision in a contract, it's really the best practice standard anyway, thinking about those elements and what you need to show, a fair investigation, that a rule was violated and you have evidence of it. It's really a best practice anyway. And then lastly is to maintain your, positive relationships, right? What kind of environment do we want? School environment do we want? Employment environment do we want? And making sure that our conduct of those in our environment is aligned with those expectations. Next slide. So some common mistakes, we talked about this already, assuming no investigation is necessary. I think it can be very tempting when something is brought to your attention to think, oh my gosh, this is terrible. They were there. They said this is what happened, so that must be what happened, right? And maybe that's the case, but we have to make sure we're doing it fairly, we're doing it thoroughly. As the saying goes, there's three sides to a story, right? You're going to have other perspectives. So it's important to give due process to the person accused, to hear them out, to hear from witnesses, to make sure you have the full story, because it may be exactly what you think, but it may not be. And that's not to say that anyone is lying to you or making a story up, but everyone has their own perspective and there may be misunderstandings. And if you kind of forego an investigation, you're going to miss out on all that important information. Another mistake is, interviewing the wrongdoer with their determination in hand, thinking, gee, I know where this is going to go. I've got my termination letter here. I've got my, suspension letter, whatever it is. And thinking that you already know where the investigation has come out. Next slide. It's really important, especially today. I think prompt action. I think parents, students, employees have a very high demand, high expectation that you're going to get to this issue and you're going to do it right away. And that can be a real challenge because often it's not the only thing on your plate, right? It would be lovely if we could drop everything and give every issue a full investigation right then, but that's really not reality. So you're going to want to use your judgment and making sure we take action to show that we're beginning something. We've received the complaint. We're going to be working on it, and using your judgment to say, this is something that needs to be handled really quickly. And I need to take, immediate action of some sort, and something that says, I need to pause things here. I need to do a full investigation. So it's going to be a judgment call. When you make that call, think about justifying the course of action, why you did these things, right? And as frustrating as it may be, because you're busy or you had a lot of other stuff going on, usually is not going to be a satisfactory reason to, an investigator, an arbitrator, those kinds of people. So think about what the justifications are. Think if there's any interim measures you need to put into place. An investigation can take some time, right? A full investigation can take a lot of time. In the interim, these people might be interacting with one another. There may be the concern about additional harm happening. So there may be interim measures that you need to take, and that may help kind of give you time to finish that investigation. Documenting why you did that can be really helpful. If it's a student, contacting the parents, letting them know what's happening can be really helpful. I mean, if you put yourselves in the complainant's perspective or a parent's perspective, oftentimes this is the most important thing that's happening right there in their lives. And hearing that you received the complaint, you understand it's serious, and we're going to be looking into it can go a long way. That communication of just, this is what's happening, this is a status, please give us the time to make sure we do this properly, but this is what's happening can really go a long way. On the last piece is making sure you follow your own policies, and you have to know your policies to do that. So some policies may indicate a specific timeline. We're going to get this concluded in 5 days. We're going to get this concluded in 2 weeks. If you don't follow your own policy, that's a problem. So you have to be able to know what's in there. And side note, whenever I do review of policies, I typically don't like that language because it is very hard to guarantee an investigation is going to be done within a strict timeline because there are so many variables, as we'll talk about. But it's important to know what you've guaranteed in your own policy and make sure you're compliant with that. Next slide. So before you begin, you have to decide who's going to do the investigation. You're going to have to consider the facts of each case and choose appropriately based on that. Sometimes that might be human resources. Sometimes it might be an appointed DASA coordinator or some sort of appointed officer. It might be building principal or building administrator. It might be outside legal counsel, right? And I don't think there's a one size fits all answer for those. I think it's going to depend on the facts. It's going to depend on the allegations. Next slide. When you're thinking about who can do this investigation, here's some prompts, some tips, some traits of a good investigator, and some you should avoid, right? You want them to be able to be open-minded but discreet. They obviously have to be available, or else that's not helpful. They've got to be experienced, right? They need to know the area within which they're working in. Are they familiar with DASA? Are they familiar with harassment and their policies? Do they know what they're talking about and what to look for? They need to be professional and a good communicator. Think about someone who would make a good witness, because sometimes these develop into litigation. And sometimes you do need that person who did the investigation to be your witness. So they need to be able to make a good witness. Adaptable, right? It can be really challenging. You have to have the ability to go where the interview takes you. And sometimes that's not exactly the questions you laid out. So someone who can adapt and make sure they pick up on important things and follow them. Folks who would not make a good investigator, people who tend to be gossipers, right? Who would not adhere to that confidentiality to the greatest extent possible. People who may be accused of bias, right? If they've got a very close, friendly relationship with someone involved, or if they're named in the underlying actions, like, as a principal, you're being accused of doing something, you don't want that principal to be the one conducting the investigation, because that would really undermine the integrity of the whole investigation. Next slide. Next slide. So talking about developing an investigation plan, this is the usual steps of what it looks like when you plan it out. You're going to intake the complaint. You're going to develop your plan from there. You're going to look at your policies, look at any documentation that you have right away. You're going to interview first, probably the complainant, then any witnesses you identify or have been identified, and the accused, and then any other witnesses requested. Perhaps the accused has suggested you look to someone. You would interview those people. During the process, either beginning, middle, end, wherever it makes sense to you, you're likely consulting with counsel as you go along if there are legal issues that come up or questions that you have. Based on all that, you're going to make a decision-making process and identify who are those decision makers, and then implementing those corrective actions and documenting and closing out the investigation. Next slide. When you're thinking about who could do the investigation, who's physically going to be in the room or on the virtual screen, if possible, it's really great to have two people join. That lets one person be a note taker, but also a witness. It can happen where someone you're interviewing can accuse you of saying something or dismissing something, and it can be helpful to have a witness to say what actually happened in there. So as a note taker and a witness, if possible, great to have two. Sometimes it's just not feasible and you have to do the best with what you have, but if possible, two is great. Determine if you're going to need other experts. Is this like a computer forensic specialist are you going to need? Do you need involved law enforcement, some kind of forensic auditor? Is there a theft issue? A private investigator? Do you need your IT involved? Do they need to track down websites or emails for you? Do you need to consult with counsel right away? Try to identify who those people might be that are going to be involved in that. And at this stage, at the outset, I think it's really important to think about, are there any potential criminal issues that are identified? And if so, consider when you're going to consult with law enforcement about that. Now, there may be requirements, abuse in the school educational setting, for example. You need to contact law enforcement. I would really advise you get the advice of counsel on that to make sure you're following the proper procedures. I think it's really common to see law enforcement involved later, and then to be kind of Monday morning quarterbacking and say, well, school district, why did you do that investigation? Law enforcement should have done this investigation. You should have contacted us earlier. And that can really put, a damper on the investigation. It can undermine the credibility of it and put you in an uncomfortable position. So I think if there's any potential, think about alerting them at the beginning. Of recent, when I've done this and advised clients to do this, a lot of times the answer is, we've looked at the allegation, we've determined that it's not a criminal issue, and school district, you can handle it as you wish. And in that case, that's actually the best scenario, because now you've checked with them, you've checked that box, you've got that confirmation, and we can follow our normal processes. So give some real thought to that, give some consultation about, when you're going to involve law enforcement and what that looks like. Next slide. You're going to obtain all the relevant documentation that's going to assist you in conducting the investigation. Create a list of things that you don't have right now, but you're going to need, right? If the complaint is about email communication, you're going to want copies of those. If it's about a voicemail, you're going to want to try to get that. Social media post, how do we go about getting those? Identify those things that you're going to need. And as a side note, for social media posts, I see, this is becoming more and more commonplace. What I like to do for social media posts is get screenshots whenever possible. And remember that we don't want to be impersonating anybody else when we go and check this information on social media. We want to make sure we have access to it and we're authorized to see it. Get a social media post, get a screenshot from the complainant, from someone who brought it to your attention. And remember that they can be deleted really easily. And make it hard for us to get access to them. So if you have something, you know it's going to be an issue, try to document it early on and try to make sure you have a copy of that. If it's for a video, for example, that someone posted, they may decide to take that down once the investigation begins. So we want to make sure that we have a copy of that so we can refer to it. You're going to also identify your potential witnesses at the outset. Who do you think you're going to need to talk to? And decide on your order of your interviews. Next slide. This is one thing that I tend to do in a lot of cases. I find it helpful to create a timeline to set out kind of what's happened next with the dates along to it, and then add to it as the investigation progresses. You don't always have to do this. You don't have to do it if you don't like it, but I think it's helpful to kind of to keep everything together and in order and give you kind of that really big picture of what's going on. Next slide. So some important considerations before beginning. Go ahead. Thanks, Kate. Next slide. The attorney-client privilege. So this can be really helpful. I'm sure most people are familiar with what that means, the attorney-client privilege, right? Communications with your attorney, remaining privileged, and not being subject to discovery later on. But you can't create it retroactively. So what the privilege is, it covers any confidential communication between an attorney and a client that was made during the course of representation. Next slide. And to determine whether or not it's privileged, courts are going to consider, did the relationship exist at the time of the communication? Meaning, if you've got a communication here about an investigation and then you retain counsel, you can't go back and create privilege over those communications. And the communication also has to be made for the purpose of obtaining and conveying legal services. So my recommendation is involve counsel early, just get their, even a 15-minute phone call can really be helpful in identifying this issue, thinking about it, and developing a plan to maintain privilege where you want to maintain it. When we're doing an investigation, it can be tempting to have, our principals or administrators email summaries to us. This is what happened, right? Or this is what I think, or all these different things. And we have to realize that communication is not privilege. So we want to be thoughtful about what we ask and when we ask for it. Next slide. When we talked about interim actions, it may be that you need to suspend or what I would actually call administrative leave with pay an employee pending the investigation. That can be for a number of reasons. It could be that you're concerned about continual harm happening while the investigation is pending, right? Whatever's been alleged is quite serious, and we don't want that to continue while it takes us, days or weeks or whatever it may be to finish our investigation. So when we're thinking about our professionals covered by the education law, though, we need to be mindful of that, because generally under the education law, suspension needs to be with pay and pending charges. Those are the requirements. There are only very limited exceptions where you can put someone out on leave without pay pending charges. So those may be if the person's facing charges for lack of certification, they've pled or found guilty of a drug crime or felony crime involving the physical abuse of a minor, and that's been pled or found guilty, not just alleged. Charges involving physical or sexual abuse of students, and those are subject to the expedited rules within the education law. And a reminder for any folks in New York City, there are negotiated alternative disciplinary procedures there. You should really consult with counsel before you do put anyone out without pay. It's important to make sure you're on the right side of that line. A superintendent can suspend with pay prior to filing the charges until the next regular board meeting. And there have been cases where it's found that suspending an individual, even with pay, without filing charges within a reasonable time has been held improper, that essentially it's been, suspending the person without the process protections of 3020A. So consult with counsel and make sure you feel comfortable in those actions that you're taking early on. Next slide. For folks that are covered by the civil service law, or civil service employees, the current version of that law does allow for suspension for up to 30 days pending a hearing, meaning that those charges need to be brought. So once you bring those charges, you can suspend without pay up to 30 days. Your collective bargaining agreements, make sure you check those because they may have alternative procedures or different requirements. There has been recent legislation that has been aimed to amend these provisions and make it really more like the education law. That has not been passed. It's been vetoed, actually. It's not gone into law. But keep an eye on that. That is a motive that's been happening. Next slide. Any other interim measures that minimize the burden on a student? So, if you're talking about an employee, that I think the consideration is, moving them, the accused person, putting them out on leave. For a student, is it a transfer to another class if the teacher is an alleged harasser, for example? Are we notifying law enforcement and getting their advice? Are we advising them that they're to have no contact in the interim? So all those things that may be, depending on the facts of the situation, things to consider with respect to students in the interim. Next slide. Go ahead, next slide, Kate, thanks. So when you're preparing for your interviews, and identify your note taker, establish a separate file. This is not something you want to keep in the student file, in the personnel file. It should be a separate confidential investigation file. You're going to want to prepare outlines for each witness. Those typically have a standard open, a standard close, and then you're going to have questions right in the middle that are sometimes the same core questions for every witness you have, but there should be some specific ones to that individual first. And it's important to think about that beforehand, to lay those out so that you make sure you get those answered. It can be hard when you get in an investigation, you get in an interview, and the person's speaking and they're talking and they're giving us all this information. You've got all this information, you're going down this road, but you forgot to ask these important things and you need to go back now. So have those laid out, make sure you address all those things that you want to address at the outset. You can anticipate questions that they may ask, confidentiality is a big one. There may be specific fact questions that they may ask about. You may want to think about what your responses are to those questions at the outset, and involving counsel if there's any legal issues. Next slide. When you schedule the interviews, consider the order. Who you want to meet with first, that may be important. It may be that despite your advisement that this should be kept confidential, that people are going to talk. So you want to make sure you're scheduling that appropriately to account for that. It may be helpful to have, witnesses done first, right? And then talk to the accused. Often, if you're talking to the accused first, you're going to have to circle back and you don't have the full facts you're asking about. So make sure you're thinking about the order. Make sure you have sufficient time for each interview. That's the interview itself and the notes. And that can really vary. So I would err on the side of giving yourself a little bit of extra time in case it goes long. Try to avoid overlap where witnesses cross each other or see that you're talking to another witness. That really undermines confidentiality. And think about any necessary accommodations that might be necessary. Next slide. For folks with wine garden rights, our unionized employees, they can request a coworker or a union rep to be present for an interview, which might lead to discipline. The district has to grant that request or forego the interview. For our civil service folks, there's an additional requirement there in Section 75. They have to be provided with written notice of the right to their union representation when questioned, if reasonably appears that the employee may be subject to disciplinary action. Next slide. So if an employee can't get that union representative right away, you can go ahead with the interview, but only if a reasonable time was given. Otherwise, that information might be excluded at the hearing. So really consider rescheduling. Of course, there's a reasonable time backdrop to all this. If the person's really just stringing you along, it's been days, it's been weeks, and they can't arrange for the person, and you need to go ahead with it. That may be the exception, but in most cases, you're going to want to reschedule. You're going to want to remove that as an obstacle that, gee, I didn't have union representation. You made me talk anyway. So give that some thought on whether or not you press forward without a union rep. Do that with caution. And also check your CBA. Make sure there's no additional specific specifications about wine garden notices or rights to a union rep in there or who may be notified. When you're talking about students, consider the notice to the parents. Sometimes we may be interviewing students. Our building admin may pull them out, may interview our students about an issue, and that's perfectly fine. Sometimes we want to let the parents know we're doing that. If there's a suspected criminal issue, if the parents are the one who complained, you might want to just put them on notice of that. And in some occasions, if you've got an outside individual, for example, doing the investigation, you might want to offer the parents the opportunity to join in at least part of the interview. Sometimes with DASA interviews, for example, where a parent is the one who's making the complaint on behalf of the student, oftentimes we will schedule it so that we can talk to the parent, we can talk to the parent and the student, and we can talk to the student kind of in like 3 phases of the interview. So that's something to consider, that communication. Next slide. Location's appropriate, right? You want to make sure you're thinking about that. Is it where everyone in the office can hear? Are you in an open cubicle? That's not the greatest idea. You want to not be in a fishbowl. You know, we have some, lovely conference rooms that are glass. You might have the same thing where there's lots of windows. That's not always the best option if there's going to be people walking by, and you kind of want to avoid that. Avoid the parade where everyone can see what you're doing. And of course, we're never going to keep someone confined in the room. Sounds silly, but those claims have been made, those false imprisonment claims. Next slide. Next slide. Talking about conducting effective interviews. So you're opening, right? This is where you can introduce yourself if you don't know the individual, explain the purpose of the individual, why to the interview, why you've asked to speak with them, your role, anybody else who's a parent who's there. This is a note taker. This is who they are. They're going to be observing. Tell them that you haven't reached a conclusion yet, that you are conducting this fact finding. Now is a time, I think, especially in today's environment, to inquire about recording devices at the outset of an investigation. It's really, really easy to record something surreptitiously nowadays. And in some ways, if people want to do that, there might be not a lot you can do to stop them. But what I like to do is to say, I want to confirm that I'm not recording. I want to confirm that you're not either, and have them make that confirmation. Worst case scenario, you ask for the entire recording when it comes up as an exhibit, and you've got them on the recording saying, yes, I agree not to record. And of course they've done so. But I think that's a good thing to address right away and make sure everyone understands the expectations there. I think it's important at the outset to address your anti-retaliation message and confidentiality. And that goes to them of asking them not to discuss the investigation while it's pending. And next slide for some more considerations on that. Before you do that, per the NLRB, they really want to see an individual assessment of the need for confidentiality. Why do we need this witness to not discuss this with someone else in the interim, except for the union rep, for example? Is there witnesses in need of protection? Is there risk of evidence being destroyed, testimony fabricated, or to prevent some sort of cover up? And if you can show that those exist, and in a lot of cases they do, that justifies you being able to say, please keep this confidential in the interim, right? We're not trying to unnecessarily gag anyone, but want to maintain confidentiality because it's important to the investigation. If it involves protected activity, for your unionized folks especially, make sure you consult with counsel about that before you're giving that confidentiality directive. Next slide. Taking action to defend against retaliation. I think one of the most important things you can do is to issue that anti-retaliation statement, and make sure everyone is aware of those expectations, who they can report to if they feel that's happening, documenting that you've done that in your notes. Depending on the scenario, you may want to prepare a written statement and get their signature that they've been advised of that. After you've received a complaint, oftentimes that complaint itself is going to be protected activity, no matter how the investigation turns out, right? So you want to make sure that HR is advised and notified about employment actions that may happen after the fact, right? And it's not to say that nothing can happen. You make a complaint, you're not protected in the future forevermore, but you are protected against negative actions because you made the complaint. So it's important that if an employment action is going to happen, you've got your ducks in a row, you have your justification that it's because of this issue, it's not related to this complaint or protected activity. So that communication is really important to just make sure everyone's on the same page. Next slide. Closing your interview. So after every interview, you're going to want to make sure you review, make sure you understand the key points, look for notes of any follow-ups you may need. Often when I do interviews, I will make either, if I'm doing a typing, a highlighted notation, you know, green means that's something I need them to provide me with or follow up with, or I make a note in the margin if it's a handwriting, meaning that's a question that came up in my mind while they were talking. I didn't want to interrupt them, but I want to make sure I get that answer too. So make sure, skim over your notes, make sure you've got everything covered that you wanted to. If there's anything that's, you know, you need clarification on or completeness, go ahead and take that time to do it then. And I always like to end by asking, is there anything else you think I should know? Because I may have had these great questions and I think it answers everything, but there may be some really key piece of evidence that just because I didn't ask a specific question about, it's really important that I know that. So I like to ask that question, give them the opportunity to say, gee, you should also be aware of this. And then consider whether you want a signed and dated statement from that individual. Especially with students, that might be really helpful to get that statement from them that's signed and dated as to what happened. Sometimes employment areas that also can be helpful. I think it depends on the scenario, how complicated the matter is. Is it something you want a statement for? So consider if that's something you want to ask for. Next slide. Special considerations when you're interviewing the complainant. So often this is the first one that you will do. You want to involve a witness whenever possible for those reasons we discussed. You want to thank them for coming forward, assure them that you take it seriously, address any retaliation concerns that they may have, and ask them about any immediate concerns regarding safety or interim measures needed. Have that discussion with them at the outset. Next slide. You want to get the facts, right? You want to fully understand what it is that they're complaining about. And especially if you've got a written complaint, that can be very vague, can be very general. So you really want to drill down into the who, what, where, whens, since when, past history, all of those really important facts. You want to ask who else has they discussed this with anybody else? Have they made this complaint to anyone else? Have they had contemporary discussions with anyone else about this issue? Are there any witnesses that are around when this happened? Any other proof? Do you have notes? Do you have an email? Do you have, you know, a video? Any other proof that they may have of these things that have happened that they are alleging? Next slide. I think it's helpful when you have a complainant to inquire how they would like the complaint resolved. And I like to say that with the caveat to them that I don't want to give you the impression that whatever you ask for is going to be granted, right? The whole point of doing this is that I'm doing a fact finding. I want to make sure I understand what you're asking for, but I'm not guaranteeing any results. So you want to make sure you limit that expectation there. But I think it is really helpful to have that perspective. We can make assumptions about what we think they might want out of it, but it might be something really different, right? It might be they're looking for a transfer. They're looking for, you know, they want to resign and they want money out of this. It might be that they just want it to stop. It might be that they want something removed from a file, right? So really asking that at the when you're interviewing the complainant can be really helpful. And again, just for gaining their perspective. Establish a follow-up, excuse me, with them. So you may give them an estimate of a timeline. I'm going to be back to you in 1 week, in 2 weeks, at least to give you a status update if this isn't concluded by them. So they know that there's going to be follow-up. Again, this is a really important thing in their life. And while you're doing all your hard work, interviewing things and looking at documents and consulting with people and really putting in the work on this, to them, they're hearing nothing, right? So establishing that follow-up time can be really helpful in kind of managing their expectations. And again, consider whether you want a written statement of the facts that you've intaked at that point in time. And I think, again, that just depends on the investigation. Sometimes you do, sometimes you may not. Next slide. Some common mistakes, especially with a complainant, failing to schedule that promptly, at least get the ball rolling there so they can see that immediate action is happening. Even if it takes you a day or two to get to the next witness, scheduling that promptly can be really helpful. This is a trap that I know I've talked about. People have probably heard me say this before, or your counsel say this before. You can't honor a do nothing request most of the time. It's a trap, whether it's well-intentioned or not. People may come forward and say, I don't want you to do anything about this. I just want you to be aware that this is happening. You can keep an eye on it, but don't do anything. A lot of times we have an obligation to do something, right? To address that, maybe by law or by our policy. And I think we have to make it clear to them that, you're bringing this concern to my attention. It's a serious one. If this is happening, I want to help you. I want to make sure that this doesn't happen anymore. So I have an obligation to address this, right? So it's important that you don't say, you got it, I'm just going to listen to you, but I'm not going to do anything about it, right? Don't fall into the trap, because inevitably 2-3 months down the road, they'll come back again, maybe to your boss, maybe to someone else, and say, I told this person about this and they did nothing. So don't fall for that trap. You can't also promise absolute confidentiality. You need to conduct an investigation, right? You have to interview the accused, other witnesses. So you can promise confidentiality to the greatest extent possible, commensurate with being able to conduct an investigation. And that's not absolute confidentiality. And the way I like to explain that to complainants is, gee, if I say I'm going to promise you 100% confidentiality, that means I hear what you say, I keep it in my own little silo, and nothing happens with that. That's not what either of us want, right? I want to be able to look into this to address this. So I'm going to keep that at top of mind wherever possible. I'm going to keep confidentiality upheld to the greatest extent, but I can't promise you 100% confidentiality. In most cases, right? Don't rush to a judgment. Make sure, it may sound bad from the complainant. Make sure you get the full story from your witnesses, from your other pieces of evidence, from the accused first before you make a decision. Get that corroborating proof. A lot of times people say, oh yeah, I've got this in email. I've got this. Yeah, I've got that message. I've got this saved. And they want you to take the word for it. I will ask for that. Can you send me a copy of that email? Can you send me a screenshot of that text? And it's helpful no matter what way it goes, right? It may be confirm exactly what they said, and now you've got it in black and white, or it may be a little different, and you see that their interpretation of it may not be quite what they're saying. So make sure you get that corroborating proof from them. And again, don't promise an inflexible deadline. Keep that flexibility for yourself, as you don't know where the interview might go, where the investigation might go. Next slide. So what's next? So do you need interim measures? Quick tip, don't move the complaining employee unless you get their, really that's their request, their consent to it. You don't want to walk into a retaliation claim by that. It may be necessary to look into administrative leave or suspension in the interim. Safeguarding to record your records, making sure things aren't deleted in the interim. Maybe that's touching base with IT, making sure those things are preserved and not deleted, or giving those messages to folks. Next slide. When you interview the accused, this is probably the most important one. You're going to protect their dignity. Make sure you do it in private. Be emotionally and factually prepared for it. Be ready for those hard questions you may have to ask. Be aware that you're probably going to have to make a credibility determination and ask the questions that you need to get to that. Sometimes accused can be adversarial and confrontational. Don't let them hijack your interview. Don't let them turn the questions around on you. That's not what you're there for. At the same time, if they're going to talk, you're going to listen, right? If someone wants to fill the silence, they want to talk, you want to listen to them. Next slide. For those covered under the education law or professional employees here, there is a provision of that law that says employees shall not be required to testify on their own behalf. You may hear it referred to as cadet rights. The language has been interpreted to say covered employees, you can refuse to answer questions during an investigation because that information may be admissible at a hearing. So if you've got someone covered by 3028 of the education law, you cannot compel them to answer and discipline them from noncompliance. That's very different from your other employees, but make sure you keep that in mind. Next slide. You're going to discuss what issue with them. You want to get their version, explain to them. The reason I'm speaking with you is, one, I want to put you on notice these concerns have been raised, but also hear from you and your perspective and any response or information you want me to know about. You really press for those details, really try to lock in their story at this point in time and make sure you get it in a detailed fashion. And then test those questions you know are going to be necessary for credibility, because so often your determination is going to come down on a credibility determination. And who do you think is more credible? Next slide. Consider obtaining their written statement. Again, another consideration. Advise that there's going to be another follow-up meeting, and you close the interview out. Next slide. Next slide. Some do's, inquire about any relationships between those individuals, the complainant, the witnesses, the accused. Is there some backstory you need to know? What's their motivation for timing of a complaint? If something happened a year ago, why are they bringing it up now? Why now? What's the motivation, right? Allow them to tell their story, take your notes, and ask your follow-up questions when they're done. I typically don't like to interrupt people whenever possible. I want them to get all of it out. I want that information. So I usually will make a note for myself if there's a follow-up I want to ask. Using silence to your advantage. Don't feel uncomfortable if there's silence. Use it to your advantage and prompt them to fill the silence. Oftentimes, especially people who may be nervous, will fill that silence with lots of words, and those are words that you want to hear. Be prepared to ask even those uncomfortable questions and harassment complaints, things that have happened that may make you uncomfortable. You still got to ask the question. So make sure you're mentally prepared to do that. Next slide. I like to start open-ended and then do the kind of drill down for more specifics. Next slide. Ask if they've told anybody else about this. Have they talked to anybody else about the investigation? Did they take contemporaneous notes? Do they have any evidence? Get those documents to back it up. Don't be afraid to circle back. If you have something after you've interviewed the witnesses or the accused and you want to circle back to the complainant, you can certainly do that. So don't be afraid. It's not a, one time, speak now, forever hold your peace scenario. If you need to circle back, feel free to do that for any of your witnesses. You don't want to rely on that, but if you have to, go ahead. Next slide. Don't strictly adhere to your prepared questions. They're a good guideline. Make sure you get them answered. But if it's taking you another route, be inquisitive about that. If there's a new complaint that you never heard about before, a new issue, follow up on that. Get the who, what, where, when, whys about all of that. So don't just stick rigidly to your issue. Don't answer your own questions. A trait of a good investigator is putting those hard questions out there and getting the answer. My husband is a sweet man, but he will often do this with others. He will say, well, maybe you just didn't get time to do that, or maybe that's not something you can do. Don't offer them up that answer, right? Ask the question, let them answer. I typically will not comment on, information that is outside of their interview. So who else I've talked to, what information I've gathered, let them know what other findings I have. And I, relay that as I'm keeping confidentiality to the greatest extent possible. So I typically don't reveal those facts. Hearsay. Sometimes people say, well, that's just hearsay. That's just rumor. So you don't want to hear it. I do want to hear that. I will take a note of that and make sure I understand that that is second, third hand information, but I want to hear it even if it is hearsay. We're not a court of law. We're not adhering to the strict rules of evidence. Next slide. Difficult witnesses. How do you handle them? Determine their reservations. Sometimes it's a fear of reprisal. Talk through those retaliation concerns. Try to put them at ease. Tell them that, if that's, maybe the case, but if you choose not to speak with me or provide this information, then I'm going to have to conclude it based on the information I have. And that's without the benefit of hearing from you and your story, right? And of course, those teachers and those who are protected by 3020A, they can refuse to answer. We can't punish them for that. But typically that's what I like to say. And most of the time people do want to share their perspective. If they become emotional, confrontational, consider taking a really short break, but get the answer to your question. Sometimes people cry. Sometimes they get very emotional. Take a pause, take a break, but don't let it deter you from what you need to do. And don't let vagueness slide. Don't let them give you very vague answers. Drill down to those specifics. Next slide. Making your determination supported by the information. Credibility is always going to be an issue. So just because the he said, she said doesn't mean you can't make a determination. You need to, right? So be prepared for that. Be prepared to document, things like their behavior. Were they cagey? Did they, contradict themselves? Did they make a different story? Document those things so it can support your determination. Next slide. Documenting the investigation. Sometimes you want a written report, sometimes you may not. Think about that. Be prepared to know that what you document may one day become an exhibit. That saying, like, it's very cheesy, but I like it. Dance like nobody's watching, and you should dance like nobody's watching, but you should draft this document as if it one day will be read aloud in court, because it very well might be. So keep that in mind, stick to the facts if you're going to write it. Don't make, those legal conclusions, at least without consulting with counsel first. So just be mindful before you put things in writing. Next slide. Recommending the appropriate action. Oftentimes that's going to depend on the finding and your policies or the law. Consider any mitigating circumstances, but just because they're a good employee, that doesn't excuse harassment, for example. Consider whether this is appropriate for progressive discipline, right? It's going to be informed by your conclusions and your guidelines and your policies. Next slide. Communicating the outcome is important. Not just the person who it's impacting and accused, but also complaining, getting back to them, letting them know the conclusion, the determination. You may not be able to give them personnel or student information, but you can get back to them, tell them you've concluded and what the determination was, and any managers and supervisors that may have to know. Next slide. Don't let that be the end of it. Make sure you're following up appropriately with them to make sure that no retaliation has been happening. How's it been since then? They're maintaining confidentiality. You're taking any steps to repair the educational environment if you need to. Maybe that's additional training of students or staff, maybe some new policy statements, dissemination of some information. There may be other techniques that you need to employ, but make sure we're putting those into place. The investigation itself doesn't end those efforts. Next slide. Okay, that's it. I know we ran a little bit long, so I thank you for your time. Thank you for joining me. I think that there might be some questions in the Q&A. We'll try to take a look at those and get back to everybody. I think the materials are going to be delivered to anybody who attended today. So thank you very much. I hope you have a great rest of your day.